speaking as someone who advises clients navigating this gap, I want to push back gently on the framing that legislative gap is a crisis waiting for a legislative cure. In our practice, our gap is already being filled, and this is not through the statutes. AI is forcing from traditional reactive compliance to ex-ante legal engineering. Traditionally, law followed business. Strategy first, lawyers after. With AI, that model breaks down. Legal compliance moves into product design. Let me describe the stack as I see it from the advisory side. First, technical standards. When canceling a client AI deployment, we are pointing them at the NIST Risk Management AI Framework, ISO 42001, relevant IEE standards, so soft law hardens legislation. Second, regulatory sandboxes. I've watched clients go through them as the new EU AI Act now obliges each country to have a sandbox. In Greece, we have a Bank of Greece sandbox. And this is actually we're building before the rules are written and things that regulators don't even understand at the moment. Third, and this is where I think our profession makes more of its consequential work, is a contractual allocation. We're negotiating AI-specific warranties, model documentation obligations, audit rights, incident notification clauses, and contracts move at the speed of a red line. And fourth, and I urge the panel not to miss this point, insurance. The underwriters pricing AI risks are quietly writing the operative rulebook. When I want to know what governance my clients will need in 3 years, I look at what cyber and errors and omissions carriers are demanding in their questionnaires today. So my own observation to this panel is this. The adaptive instruments that close the gap are already in the room. The risk to innovation comes not from layering these instruments, it comes from prescriptive statutes that drafted in haste just to look that they respond. So don't wait for the law to catch up. Build a stack, document the stack, and let the legislation ratify what already works. In the AI era, legality is no longer checked at the end of the process. It is engineered at the beginning. Cost change. The intuition that it tends to break down when the actor is an algorithm is a concept that assumes that our legal system, the concept of intent, was ever really about consciousness. It was not. We've been comfortably attributing intent to corporations, not conscious entities with no personal will, acting through chains of delegated decisions for well a century. We drew it through the respondeat superior. Είναι η ευθύνη του προστίσαντος for the Greeks. The law has already treated intent as an allocation tool, not as a metaphysical claim. So the question isn't whether an algorithm can intend harm. The question is, whose state of mind do we care about, and at what point of the chain? On liability allocations, I will resist the seductive idea that distributed agency demands brand new framework. We already have options already built, like strict product liability and like enterprise liability. What the EU AI Act and similar regimes actually add isn't the new theory of liability, it's stratified obligations by risk. So, specifically, who owes what duty at each stage? The foundation developer, the deployer, or the downstream user? If intent feels strained in a given case, that's a signal, not a concept. To train in this way, to deploy in this context, we need to focus that the human has a state of mind. That human owed a duty. Start there, and the chain usually untangles. I would like to say that legality has to be built into the technology itself, into the data, the model, and the decision logic. In the AI era, law is not a checkpoint. It's an architectural requirement. And also, I would like to say that EU gives with the legislation a very simple message. Innovation is welcome, but responsibility is not negotiable.